Good morning, everyone. Today is the 28th day of February 2024, and we are continuing our lectures on Nigerian company law. We have been looking at winding up or liquidation of companies. We'll take it up from there. Our focus today will be on fraudulent trading, wrongful trading. And if we have time, we'll look at transactions that can undervalue, as well as what we call fraudulent preference. So, just by way of emphasis, that when a company is being wound up, it's also a time, whenever a company is troubled, financially troubled, it's also a time where we want to do a lot of investigation. Why is this company having this problem? Why is it going down? Particularly if it is going down under insolvent liquidation. There's always the possibility that fraud may have been committed in the course of managing the company. The managers may have committed fraud, the officers, the promoters, and all that. And at this time, the liquidator or whoever is in charge of the company, definitely an insolvency practitioner, maybe the official receiver, the administrator, and all that, will be able to discover a lot of facts that have been hidden. Recall that whenever an administrator, a supervisor of a CVA, a liquidator, or a receiver manager is appointed, one of the things that is likely, one of what is very likely to happen is that the statement of the company's affairs, the books, the documents will be delivered to such person. Are you with me? Apart from the supervisor or the CVA, it is even a mandatory right. You must deliver these documents to the receiver manager, to the liquidator, or to the administrator, as the case may be. And definitely going through the company's books and assets, documents, you'll be able to discover whether or not there had been a wrongdoing in the course of the management of this company. And it is as a result of that discovery that certain things can begin to happen. So, for example, the company may have transacted at what we call an undervalue with respect to its maybe connected persons that are connected to the company's manager, directors, and all that, is the wife, the children, and underage children, and all that. These persons are called connected persons. Are you with me? Yes, so in the course of knowing why did this company go down, you will now discover that the company had acquired an 18-seater Hiace bus for 30 million naira and sold it for a pittance to somebody for 200,000. Particularly when it has started going down, when insolvency has already commenced. So those are some wrongs that may be unearthed by this insolvency practitioner. He may also discover that the company has done what we call a fraudulent preference. Fraudulent preference. So, for example, you know about floating charge holders. The first in time will have priority. Is that also? Yeah, because of the conflicting equities. And so, in order to give, Mr. Gwebe is my friend, he supported my political campaign. Now, in order to give him preference, I may change the date for his charge and bring it forward. Are you with me so far? And say, okay, zone was created in 1987, and then Ordinaka zone was created in 1994. Automatically, he will have priority. That is called a fraudulent preference. We may also mortgage the assets of the company to this young lady. All of them are not done with good intention. Of course, if the company is receiving money, valuable money, for any of these transactions, that may be totally different. But usually, for the most part, there will not be adequate consideration. And so the liquidator or the insolvency practitioner, as the case may be, will now be able to discover there's wrongdoing here, there's wrongdoing here, there's wrongdoing here, and then there's wrongdoing there. And should now be able to do two things. Number one, he should be able to go after those transactions, to declare them null and void, at least to get a court to nullify all those transactions. Are you with me so far? And secondly, he should be able to go against the persons involved in this wrongdoing, either by way of disqualifications. So if you recall, in section 280, we looked at it when we dealt with directors, disqualification of directors. If during liquidation of a company it becomes obvious that fraud, crime has been committed, as the case may be, among other things, the liquidator himself can approach the court and say, "My Lord, this man, disqualify them for not more than 10 years from directing any company whatsoever." And of course, criminal proceedings can also be instituted against such persons, as the case may be. Are you with me so far? Yes. So we don't have so much time. We are hoping that they will postpone the exam. I'm going to send it today, but if they don't, then we will be looking at next week. So let's see what we can do. Let's say a few things about fraudulent trading and then wrongful trading. Then if we have more time, we'll just say a few things about transactions at an undervalue and fraudulent preference. And you add it to what you already know, you become an expert in company law. I was with some of my students in the law school in Port Harcourt, and they were happy. And when it comes to company law, it's always like that. The feedback is always positive. And when you also go, you will discover that you are a head topper. And most of your, as far as this course is concerned, you will discover that you are a head. In fact, there are some lecturers of company law you will meet. When you talk to them, they will learn. I'm not boasting. They will learn from you. Because what I'm teaching is a compendium of articles. You don't use textbooks to teach. Many people use textbooks to teach. We use articles, so we gather. And so when we bring it, you can't know where we're coming from. Okay, so let's talk about fraudulent trading. Section 672 deals with that. I'll run through it. Where during winding up, it is revealed that the business of a company was carried out recklessly, number one, recklessly, number two, with intention to defraud creditors, number three, for any fraudulent purpose. We are winding up this company, Smith. We have appointed a liquidator or an official receiver, and he now discovers these guys were reckless. When you talk about reckless, then you are not careful. You care less about the consequences of your action. Is that not so? So they manage this company recklessly. There should be consequence for that. You shouldn't manage a company recklessly. So even if your intention was not fraudulent, we can still punish you for being reckless. Are you with me? You remember criminal law? You talked about it in criminal law. Is that also? Section 24 and all that. You can't drive a car recklessly and kill somebody and say, "My Lord, my intention was pure." There was no fraudulent intent. There was no criminal intent. We impute or we impose liability upon you by virtue of the fact that you are reckless. Are you with me so far? So that is the first provision. Number two, you manage the company with an intention to defraud creditors. Are you with me? With an intention to defraud the company's creditors. You have collected money for a specific purpose. You went to a bank to take 20 million naira and you told them that you want to use it to expand your business from Asoma. The moment you got that money, you filtered it. The directors shared the money. There was an intention to defraud the creditors of the company. Or you secure the creditors' money with a particular asset and fraudulently dissipated that asset. Are you with me so far? Good. Or for any other, this one is wide, for any other fraudulent purpose at all. You manage this company for any fraudulent purpose at all. When we discover this, we can approach the court and to say, "My Lord, anybody involved, the directors, the employees, the law, the barrister, the solicitor, the internal auditor, anybody who was a party to such an action should bear liability." We can approach the court. Are you with me so far? Who can approach the court in this circumstance? You should know. It could be the official receiver, it could be the liquidator, it could be any creditor or contributory of the company. I take it again. It could be the official receiver, it could be the liquidator of the company, it could be any creditor or contributory of the company. He can approach the court and ask the court to declare, look at the sanction, to declare that all those who were parties to this wahala should bear liability for it, without any limitation of liability. Section 672. There is no cap on their sanction. They should pay everything. If there are 5 of them that took this money and only one of them has money, the other 4 are paupers, then that one that has the money should pay everything. That's what we're saying. It's not proportional liability, it's unlimited liability. I hope you are clear. I hope you are clear. Yeah, so you could approach the court, say, my Lord, declare that such persons, without any limitation of liability, should bear the consequences for this action. So this basically is what we are talking about fraudulent trading. You find that in section 672, and then the court can now declare you are going to bear unlimited liability for this particular action because you manage the company recklessly with a fraudulent intent or for a fraudulent purpose. In so doing, if you already had a charge, if monies were due to you from the company, the court can now ask the company to seize that money. I don't even understand. Are you with me? Yes, so the court, basically, any entitlement due to you from the company can be used to settle that problem that you have caused. So you see that in section 672, subsection 2. Furthermore, the court may provide that the liability of any such person under his declaration shall be a charge on any debt obligation due from the company to him. The company was owing you. Now the company said, now your money, we are seizing it. On any mortgage, charge or interest in any mortgage. The company had mortgaged an asset to you. The company had mortgaged an asset to you. So you had control over that asset. Now that we have found out that you had fraudulently traded, the company is going to have a charge over that your right. A charge on assets of the company that are held by or vested in him, or on any person that claim as assignee from him or through him. So basically, in summation, anything that belongs to you, the company can proceed against it, and then the court can make any other further orders that are necessary to enforce any such charge. But in addition to this, section 672 sub 3 now also imposes criminal liability. It is also an offense. It is also an offense if the business of the company was conducted with fraudulent intent or in order to, with fraudulent intent to defraud creditors or for any other fraudulent purpose. So, in addition to, so the first imposition of liability is a civil sanction. The court is saying, Oga, you were guilty of fraudulent trading, pay the company. That is a civil sanction. In addition to that one, we can also impose a criminal sanction upon you. Are you with me? But for me to do that, the reckless intention will not apply. If you had managed the company recklessly, you will only have the civil penalty of paying money. But if you had managed the company with a fraudulent intent in order to defraud creditors or for a fraudulent purpose, in addition to telling you to pay money, the court can also impose a fine or imprison you for 2 years. I hope that is clear. Good. The problem we have is that most of these laws, in fact, the people who are enforcing the law don't even know that they exist. That is the problem. If you call somebody now from CAC, do you know of this law? You may not know. This is what I say. We have director's declaration. It has been in our statute books for 30 years. To my knowledge, it has never been enforced once. The judges are not aware. Because the law provides that if you are going to convict somebody who is a director who has committed fraud, at the point of convicting him, the judge can suo motu disqualify him. So someone like Cecilia Ibrona, who was convicted for fraud, Oceanic Bank, you don't just give her 6 months imprisonment. You also disqualify her. Madam, you are unfit to direct any company for the next 15 years or 10 years. Our law says 10 years. That will cause a lot of them to sit up. But it's not the case. And so they will just go back and set up another company and begin to make noise all over the place. There was one man that was convicted, Tafa Balogun. Those of you who are elderly, you know about him? Yeah. Yes, he was Inspector General of Police. Very fraudulent man. It was his sickness. He was convicted and imprisoned. They gave him a soft landing, I think 6 months. When he came out of prison, instead of him to humble himself in shame, he was giving public speech and he said, I will be back. Obasanjo said, you said you will be back. Oh yeah, slam him another, prosecute him again. Are you with me? Yes, I love Obasanjo so much. He said, prosecute him again. As they wanted to prosecute him, he now came and said, I am really sorry. It's not, you should be sorry for the bad that you did. Not that I will be back. Okay, let's go. See section 672 subsection 4. 672 subsection 4, essentially an emphasis on 672 subsection 3. The declaration of the court shall be made notwithstanding that the person concerned may be criminally liable in respect of matters which are grounds for the declaration, and the declaration, if made, is deemed to be a final judgment of the court. Okay, so essentially, that is what you need to know about fraudulent trading. In summary, Joseph, what is fraudulent trading? Don't manage a company recklessly, fraudulently, or with an intention to defraud creditors. If you do that, when we are liquidating the company, if we discover, we can approach the court to ask you to pay the money, and you may go to prison. That is all. Is that okay? Who can approach the court? Liquidator, contributory, official retrieve. That is all. That is all you need to know. Now we come to wrongful trading. Wrongful trading, section 673, it was a later addition. The reason is because to convict a person for fraudulent trading or to find a person liable for fraudulent trading, you must prove the fraud intent. Is that so? The fraud element must be proved. And that is a criminal offense. You know that. You must prove it beyond reasonable doubt. Even if you are going to do that in a civil case. Miracle, are you with me? Even if it's in a civil case, you are alleging that he managed this company fraudulently. We know that for a civil case, all you need is a balance of probability. Is that so? But when there's a fraudulent element, you know you must take it high. You are aware of that. And prove that particular fraudulent element beyond what? Reasonable doubt. And that became a problem. You prove what is in somebody's mind. Fraudulent intent. It's always not very easy to establish. And so we now said, let's come down a bit and bring a civil sanction. So that if we can hold you for fraudulent trading, at least we can hold you for wrongful trading. The only difference is that when we come to wrongful trading, the only person that can be proceeded against is the director of the company. You cannot proceed against any person. Fraudulent trading is wide enough to encompass any person. Are you with me so far? Are you sure? Good. So, for wrongful trading, on to see section 673, the court may require a director to contribute to the assets of a company which goes into insolvent liquidation on the application of the liquidator. Again, here, the only person that can complain is the liquidator. So wrongful trading is more constrained. I may ask you in the exam to compare fraudulent trading with wrongful trading. I think I have asked somebody, anything I say I may ask you in the exam, I told somebody to be writing it. Who is that person? Good, I hope you have been writing. Send them all to me. So, this is the difference. Wrongful trading is that At some point before the company went into liquidation, you ought to have known that there's no way this company will not go down. And so you ought to have stopped trading. Instead, you continue to trade. Are you with me? Joseph, are you with me? You knew that this company was going down. This company is going to be liquidated. There's no way this company will not go down between now and May. You went to collect loan from UBA, 2 years loan. Okay, why are you doing like that? You went to collect supplies, timber supplies, cement supplies on loan. So we'll pay you between now and the end of the year. But you knew. Joseph, are you with me? That this company is going down. The law says you should have stopped trading at that time. So that you're not in due, because you have information that other people don't have. You have taken advantage of an information that you have that they don't have. What is the information? This company is going down. They don't know. Comfort, are you with me? And so they are not trading with you innocently, only to discover that the company is going down. You have now made them creditors. You have now made them, you have jeopardized their interests. They now have to join the rest of the creditors. If they had known of this information, they would probably not have traded with you. So at some point before winding up, the director knew or ought to have known that there was no reasonable prospect of the company avoiding insolvent liquidation. Then the court can say, upon the application of the liquidator, the court can say, okay, that money that this company is to pay Koan, you too, you will contribute. You will contribute something. That is your penalty. The only defense is that he took every step to minimize losses to creditors. He took every step to minimize losses to the company's creditors. He took every step. Now we say he knew or ought to have known. That is the acid test. If he did not know, then we cannot sanction him, we cannot punish him. But if he knew or he ought to have known, then we can punish him. Are you with me so far? Are you with me so far? Good people. So, what is the test for determining if he knew or ought to have known? How do we test the conclusions that he ought to have reached and the steps that he should have taken? How? What we are going to use are two tests, two different criteria. Number one is we are going to ask those which would have been known or ascertained or reached or taken by a reasonably diligent person. A reasonably diligent person should have been able to know that there's no way this company will not go down. Or should have been able to take adequate steps to preserve or protect the interests of the creditors. Are you with me so far? That is what we're going to look at section 673 sub 4. Let's just look at it together, even though my time is gone. For the purposes of subsections 2 and 3, the facts which a director of a company ought to know or ascertain, and the conclusions which he ought to reach, and the steps which he ought to take, are those which will be known or ascertained or reached or taken by a reasonably diligent person who has the general knowledge, skill, and experience that may be reasonably expected of a person carrying out the same functions as are carried out by the director in relation to the company. Would a reasonably diligent director of a chemical engineering company, having seen the reports, the accounts, the audited reports, and then the statement of affairs of the company, have been able to come to the conclusion that this company is going down? If the answer is yes, then okay, you have no excuse. So you will not say, my Lord, I did not know. I did not know is not what we want to hear. Will the person in your condition have known? Yes, that person in my condition will have known. If he was extremely diligent, no. Reasonably diligent. averagely. If such an average person would have known, then Oga, and you have no excuse, bring the money. You're not serious. I hope you are clear. Good. Number 2, the general knowledge, skill, and experience of that director himself will now be like the second test. So it is even possible that a reasonably diligent director will not have been able to know that fact. But you are not a reasonably diligent. In fact, your own knowledge is even above that of the ordinary director. Are you with me so far? So we will consider first test is what will a normal director who is prudent have been able to know. The lecturer has given assignments, is submit in 3 weeks. Will a reasonably diligent student be ready? Then you have no excuse. The test is 8 o'clock. Will a reasonably diligent student be here by 8? Yes. You came by 8:40, 8:45. They told you to go. You start to cry, you start to beg, you start to do all those African sentimental matter. You start to use people to call on phone. It is wrong. So reasonably diligent and skilled. And very, very important and very crucial. My son, pause that in. Pause it. Can we continue? Yes, good. So we're almost done. So basically, that is what you need to know about wrongful trading and about fraudulent trading. It's a very straightforward topic, but you should know it. Now, there are some things I want you to look at. I think I talked about it in my video. Fraudulent preference. Let's run through and say a few things. We will not go into too much details. Section 658. Again, from the onset of insolvency, when the company goes into insolvency essentially, or into administration, when the company goes into winding up to administration. From that time that the company goes into winding up or goes into administration, its directors, please look up, its directors and managers are not allowed to give undue advantage to one creditor over the other, or to one surety over the other, or to one guarantor over the other. Undue advantage. Treat all of them on the same platform. A classic example is Victoria Edo2. Please look up. Victoria Edo2 is our guarantor. We have collected money from Grace Sample. Grace Sample needs a guarantee that she will be repaid. And so, Edo2 has done that guarantee for Grace. This is the company, not me anyway. That is the company, and it is going into insolvency. The moment it goes into insolvency, she will have a right against Victoria. But apart from Victoria, Auntie Sandra is also a guarantor for the company's debt. Both of them should be exposed to this lady who is the creditor of the company. Are you with me? We want to give her an undue advantage. We quickly, please look up, we quickly settle the indebtedness of the company as far as this madam is concerned. So that money that we collected, and that thing you supplied to us that Victoria guaranteed to have paid, so that she can now only sue Sandra. We said no, at this point of insolvency, you are not meant to do, you must treat everybody on an equal footing. If we have creditors, treat all of them well. Don't quickly pay one person. Are you with me? Yes, don't quickly pay one creditor and say, you. Please, if the company is going into insolvency, there's not much we can do. A liquidator has been appointed. Let him come in and let's see what he will do. Then quickly we have settled Koan. You can't do that. Please, why the movement?
Sorry, sir. They want to go and find trust first.
It's okay. No problem about that.
Yeah, go on, right.
Secondly, please let's continue. Any conveyance or assignment any conveyance or assignment of the property of the company to trustees in that regard would also be void. That is number 2. You cannot convey, you cannot assign. You cannot convey and you cannot assign the property of the company in furtherance to that trust. Again, we have 2 creditors. Please look up. We have 2 creditors. They are both unsecured. If we go into liquidation, the liquidator should be able to treat both of them on the same platform. Quickly, we carry this bottle and say, we have given it to you, Grace. We have settled you. Then you, Sandra, you are unsecured. Grace, allow me to focus. Good. And you, Sandra, you are unsecured. But Grace, you have settled. You can't do that. That's what we are saying. You cannot just do 2 floating charges and say, you will have paid you will have not paid you. Wait. Any such thing is deemed to be a fraudulent preference. You know, preference simply means putting one ahead of the other. Can we continue, please? Yes. Are there exceptions? Yes. But we don't want to take too much time to look at the exceptions. Please take your time and look at section 658. Are there defenses? Yes. There are defenses. The act was not done with the intention of giving the person undue advantage. The preference was done to a connected person. If the preference was done to a connected person, then the difference is that that person was also an employee. So if the person was an employee, he can have some relief and all that. So please, we would now then, I want you to also note that there's what they call transactions at an undervalue, section 659. Again, just to know that on a general note, when liquidation is on, you don't have the right to begin to undervalue the company's assets and sell them. Basically. Thank you. So you can stop the recording.